I sat in the glass-walled conference room at TechVantage Corporation while my boss, Derek Hammond, stood at the head of the mahogany table with our company lawyer, Paul Hendricks, beside him. Derek had just discovered my side startup, Night Owl Analytics, gained 15,000 users overnight. He smirked and told me my employment contract meant TechVantage owned everything I created. I reached into my leather portfolio and slid my original offer letter across the table to Paul. He read one line, and his face went completely white. Derek's smirk vanished instantly. Let me take you back 6 years to explain how I ended up in that conference room fighting for everything I had built. I was 26 years old when I first walked into TechVantage for my interview. The company was a mid-sized analytics software firm in Austin, and I had just come from a smaller startup that folded after running out of funding. I needed stability. I needed a paycheck. I needed to prove I could build something that lasted. Derek Hammond interviewed me personally. Back then he was the VP of engineering, not yet the Chief Technology Officer. He had this easy charm that made you feel like you were talking to a mentor rather than a potential boss. He leaned back in his chair and told me about the growth opportunities at TechVantage, the mentorship program, how they valued innovation and rewarded hard work. He made promises. Verbal ones, the kind that sound solid in a sunny conference room but disappear like smoke when you try to hold on to them later. Rapid advancement, he said. Equity grants for top performers. A place where engineers could really make their mark. I wanted to believe him. I needed to believe him. When we got to the offer letter stage, I negotiated hard. I had learned from my previous startup that you protect yourself from day one. I specifically requested one clause be added to my employment agreement. It read, "Employee retains full ownership of any inventions, code, or intellectual property created outside of work hours, using personal equipment, and unrelated to current company products or business direction." The HR representative, Gloria Patterson, pushed back immediately. She was a thin woman in her 40s, with nervous hands that shuffled papers constantly. She said the clause was unusual, that TechVantage typically retained broad IP rights over anything employees created. Derek interrupted her. He waved his hand dismissively and told Gloria it was fine, that they hired the best people and trusted them. He looked at me with that same easy smile and said it was just boilerplate protection, nothing to worry about. I thought it was standard. I thought I was being smart. I signed the offer letter 2 days later and started work within 2 weeks. Those first months at TechVantage felt promising. I joined the data visualization department when it was just 4 people working on a product that barely functioned. I threw myself into the code, rebuilding core systems, implementing new algorithms, staying late every night to make something people would actually want to use. By my second year, I was leading the team. By my third year, we had grown to 18 engineers. By my fourth year, our product had become TechVantage's flagship offering, generating 60% of the company's total revenue. I requested a raise every single year during my annual review. Every single year, Derek denied it. The reasons changed, but the outcomes stayed the same. Budget constraints, he said the first time. Company performance targets not met, he said the second time. Your equity is your real compensation, he said the third time. But those equity grants he had promised in my interview never materialized. My salary stayed frozen at $82,000, while the industry standard for my role climbed to $130,000. I watched less productive colleagues get promoted around me. Most of them were friends Derek knew from his MBA program at Stanford. They would show up to work at 10 in the morning, leave at 4 in the afternoon, and somehow end up with director titles in corner offices. Meanwhile, I took on more responsibility without any title changes. I managed the largest engineering team in the company. I spoke at conferences representing TechVantage. I interviewed every candidate who joined the department. And Derek took credit for everything my team built. In executive meetings, he would present our innovations as his own strategic vision. I sat in the back of those meetings and watched him describe algorithms I had personally written as if he understood the math behind them. I told myself it was just corporate politics. I told myself I was learning valuable lessons. I told myself that eventually the hard work would pay off. 14 months before that conference room confrontation, something inside me snapped. I was sitting in another annual review meeting where Derek explained why I would not be getting a raise again. He said something about market conditions and shareholder expectations. I nodded and smiled and said I understood. Then, I went home to my apartment, opened my personal laptop, and started building something of my own. I called it Night Owl Analytics. The idea was simple. Freelancers and small businesses needed a way to track project profitability in real time. They needed to see which clients were worth their time and which projects were draining resources without providing adequate return. The existing tools were either too expensive or too complicated for solo operators and tiny teams. My tool would be different. Clean interface, powerful features, affordable pricing. It was completely different from what TechVantage did. They focused on enterprise clients with massive datasets and complex integrations. I was building something for individuals and small teams who just needed clarity about their business finances. I built Night Owl entirely on weekends and evenings. I used my personal laptop, my own internet connection, my own savings to pay for hosting and development tools. I used a completely different technology stack than anything TechVantage worked with. I never touched company equipment. I never worked on it during business hours. I told exactly one person about it, my roommate Jordan Martinez, who worked in graphic design and helped me create the logo. He promised to keep it quiet. I soft-launched Night Owl 8 months after I started building it. Growth was slow at first. 300 users over 6 months. Modest monthly revenue of about $2,000. It was exciting but manageable. I could handle the customer support emails in an hour each evening. I could maintain the servers without too much stress. Then, 3 days before that conference room meeting, everything changed. A popular business podcast host named Trevor Chen discovered Night Owl somehow. He mentioned it on his show, which had over 2 million regular listeners. He spent 5 minutes explaining how it helped him finally understand which of his consulting projects were profitable and which were just keeping him busy without making money. That night, I watched the user count explode. 15,000 new signups in 24 hours. The servers crashed twice. I spent the entire night scrambling to scale the infrastructure, moving to bigger hosting plans, optimizing database queries, adding capacity as fast as I could. By morning, I had $47,000 in monthly recurring revenue. By afternoon, I had 12 venture capital firms emailing me asking for meetings. I was exhausted and exhilarated and terrified all at once. This was real. This was actually happening. My side project was becoming a legitimate business. I updated my LinkedIn profile that evening to reflect my new reality. I added founder at Night Owl Analytics to my experience section. The platform updated it automatically. Derek saw it the next morning. He called me into his office at 9:30. I walked in expecting maybe a regular check-in or a question about one of our projects. Instead, I found him sitting behind his desk with his arms crossed and his face red. He demanded to know about this little side hustle I was running. His exact words, "Little side hustle." I explained calmly that Night Owl was completely separate from TechVantage. Different market, different technology, built entirely on my own time with my own resources. I reminded him of the clause in my original offer letter protecting my personal projects. Derek's face turned darker red. He called me disloyal. He called me ungrateful. He said I had taken everything TechVantage taught me and used it to build something behind their backs. I tried to explain again, but he cut me off. He told me we would discuss this tomorrow with legal representation present. He said I should bring any documentation I thought was relevant. Then he dismissed me from his office. I barely slept that night. The next morning, I walked into the glass-walled conference room carrying my leather portfolio with every employment document I had ever signed at TechVantage. Derek was already there with Paul Hendricks, the company's lawyer. 3 board members sat along the side of the table looking uncomfortable. Derek started talking immediately. He said TechVantage had become aware that I had developed a software product using company resources and proprietary knowledge. He said my employment contract clearly stated that any work product created during my employment belonged to the company. I pulled out my original offer letter and slid it across the table to Paul. I pointed to the clause about personal IP ownership. I said it was clear and unambiguous. I had protected myself from day one. Paul picked up the document and read it carefully. His face went pale. He whispered something to Derek. That was the moment I thought I had won. Then Derek smiled. It was not a nice smile. He interrupted Paul and said the clause had an important exception I was forgetting. He pulled up a document on the large screen at the end of the conference room. It was my current employment agreement, the one I signed 3 years ago when I was promoted to team lead. Derek pointed to a section I had completely forgotten existed. It read, "All previous employment agreements and understandings are hereby superseded and replaced by this document. My original protection might be completely void." Everyone in the room stared at me. Derek's smile grew wider. I felt my stomach drop through the floor. The conference room felt like it was shrinking. Derek leaned forward with his elbows on the mahogany table and said I had exactly 48 hours to sign over all rights to Night Owl's code and user database. Paul explained in his careful lawyer voice that the superseding clause made my original IP protection likely unenforceable. He said TechVantage was prepared to be reasonable if I cooperated immediately. If I chose to fight, things would get much more complicated and expensive for me. I asked if I could have time to consult my own attorney. Derek shrugged and said 48 hours, not a minute more. I left the conference room on shaking legs. My team members were working at their desks in the open floor plan just outside. Several of them glanced up and noticed something was wrong. Tyler Nash, one of my senior engineers, started to ask if I was okay, but I kept walking. I could not explain. I could not form words. I went home early for the first time in 6 years. That evening, I contacted 3 employment lawyers, whose names I found through online searches and referrals. The first 2 wanted $5,000 retainers just to take my case. I did not have $5,000 sitting around. Most of my savings had gone into building and scaling Night Owl. The third lawyer, a woman named Amanda Strauss, agreed to review my documents for $800. It was still money I could barely afford, but it was possible. I scraped together the payment from my savings account and sent her everything electronically. Amanda worked through the night reviewing my case. We met the next morning at a coffee shop near the University of Texas campus. She had printed out all my documents and covered them with highlighter marks and handwritten notes. Her assessment was devastating. She confirmed that the superseding clause was standard in employment contracts and generally enforceable in Texas. The 3-year-old agreement I signed when I got promoted to team lead did legally replace my original offer letter and all its protections. She said I had been so excited about finally getting a promotion that I had not scrutinized the new contract carefully. Most people did not. It was a common mistake. Then she said something that made my blood run cold. Derek likely planned this from the beginning. He probably knew I was talented enough to create something valuable eventually. The original offer letter with the IP protection was just bait to get me in the door. The superseding clause in the promotion contract was the trap snapping shut. Amanda laid out my options in blunt terms. Option 1. Sign over Night Owl to TechVantage and try to negotiate some compensation. Maybe I could get $50,000 or $100,000. Maybe I could keep a small equity stake. It depended on how generous Derek felt. Option 2. Fight it in court. Legal fees would run between $50,000 and $100,000. The outcome was uncertain. Texas law favored employers in IP disputes. I might spend everything I had and still lose. Option 3. Shut down Night Owl entirely and claim it was not actually valuable. Walk away from everything. I had less than 24 hours left to decide. I drove around Austin for 3 hours after that meeting. I cried in my car at a park overlooking the lake. I was furious at myself for not reading that promotion contract more carefully. I was furious at Derek for being so calculating. I was furious at a system that let companies trap their employees like this. Eventually, I decided to try negotiating. Maybe if I approached it as a business transaction rather than a fight, Derek would be reasonable. Maybe I could get $200,000 and keep 10% equity. At least I would have something to show for a year of nights and weekends. I sent Derek an email requesting a meeting to discuss fair compensation for Night Owl. He replied within 10 minutes. The email said he was not interested in negotiation. Then he forwarded my message to the entire executive team with his own message attached. It read, "This is what happens when we are too lenient with employees. Chastity built a competing product on company time and now wants us to pay her for it. I am recommending immediate termination and a lawsuit for breach of contract and theft of trade secrets." The email was CC'd to the entire engineering department. My phone started exploding with text messages. Some people were supportive. Most were confused or angry. Within an hour, the story was spreading through Austin's tight-knit tech community on social media. My professional reputation was being destroyed in real time. This was no longer just about losing Night Owl. Derek was coming after my entire career. Within 2 hours of Derek's email, I was locked out of all company systems. My badge would not open the front door. My laptop credentials did not work. My email bounced back as undeliverable. HR called my personal phone at 4 in the afternoon. A woman I had never spoken with before told me I was on immediate administrative leave pending investigation of serious allegations. She said I should not contact any TechVantage employees or come to the office. She said they would be in touch. I tried calling members of my team. Tyler did not answer. Angela Park sent a text saying she was sorry, but had been instructed not to communicate with me. Nobody else responded at all. I reached out to contacts across the Austin tech industry. Recruiters I had worked with before. Engineers at other companies who had once tried to hire me away from TechVantage. Former colleagues from my previous startup. Most did not respond. A few sent brief, uncomfortable messages saying they had heard about the situation and hoped it worked out but could not get involved. The tech community on social media was divided. Some people defended me, saying companies should not own their employees' personal projects. But most assumed Derek's version of events was accurate. They figured I must have done something wrong, or TechVantage would not be taking such aggressive action. 2 days after the conference room meeting, my roommate Jordan admitted something that made everything worse. We were sitting in our small living room, and he could not look me in the eye. He said he had told his girlfriend Sarah about Night Owl 2 months earlier. He thought it was harmless. He was proud of me and wanted to share the news with someone. Sarah Brennan worked in TechVantage's marketing department. Jordan said Sarah must have mentioned it to someone, and word eventually reached Derek. He apologized repeatedly. He said he never imagined it would lead to this. I could not even be angry with him. It was my secret to keep. I should have told no one at all. The mistake was mine as much as his, but the betrayal still hurt. The financial pressure started mounting immediately. Night Owl's hosting bills had jumped to $6,000 per month because of the sudden user growth. I had $8,000 left in total savings. My TechVantage paychecks were suspended during administrative leave. Rent was due in 12 days, $2,000. I could not shut down Night Owl without angering 15,000 users who were depending on the service. But I could not afford to keep it running much longer either. 4 days after the conference room meeting, Derek sent a formal cease and desist letter through Paul. It claimed Night Owl used proprietary algorithms derived from TechVantage technology. The claim was completely false, but I would have to prove that in court with expert witnesses and technical documentation. The letter demanded I transfer the domain name, the code repository, and the entire user database to TechVantage within 7 days. If I did not comply, they would file a lawsuit seeking $5 million in damages. Paul also sent copies of the letter to every venture capital firm that had contacted me about investing in Night Owl. The letter warned them that Night Owl was built on stolen intellectual property and advised against any investment or acquisition discussions. The VC interest evaporated overnight. I felt completely alone. No job, no income, dwindling savings. A legal threat I could not afford to defend against. A business that was thriving but about to be taken from me. Then I got an unexpected message. A former TechVantage engineer named Marcus Holloway reached out through LinkedIn. I remembered Marcus vaguely. He had left the company about 8 months earlier. I had assumed he went to another job for more money, like most people did. Marcus asked if we could meet in person. He said he had information that might help me. We met at a diner on the north side of Austin the next morning. Marcus looked tired, like he had not been sleeping well. He ordered coffee and did not touch it. He told me he left TechVantage because Derek had done to him exactly what he was doing to me. Marcus had built a developer tool on his own time. Derek found out and claimed it belonged to the company. Marcus did not have the energy or resources to fight. He signed everything over and walked away. But Marcus had kept documentation of the whole process. Emails, contracts, meeting notes. He had proof that Derek followed a pattern. He had done this to at least 3 other engineers over the years. Always the same approach. Let them think they had protection, then use the superseding clause to claim ownership. Marcus said he would testify on my behalf if I decided to fight. I felt hope for the first time in days. This was evidence of a pattern. This was proof Derek operated in bad faith. We talked for over an hour about strategy and next steps. Marcus seemed genuinely committed to helping me. Then his phone rang. He looked at the screen and his face changed. He stepped outside to take the call. I watched through the diner window as he paced back and forth on the sidewalk. His shoulders slumped. His free hand rubbed his face. He came back inside looking like someone had punched him in the stomach. Derek had just offered him a $100,000 consulting contract to not testify and to sign a non-disclosure agreement. Marcus had a wife and a 9-month-old baby. He had been struggling to find steady work since leaving TechVantage. He needed the money desperately. Marcus apologized. He said he could not help me anymore. He had to think about his family. I watched my only potential witness take Derek's money and walk away. I sat alone in that diner booth for another 30 minutes, staring at my cold coffee and trying to figure out how to survive what was coming. The next morning, Jordan told me he was moving out. He said the tension in the apartment was too much. He said he felt guilty every time he looked at me. He said his girlfriend Sarah was upset that I blamed her for the situation, even though I had never said anything to her directly. I could not afford the apartment on my own. The rent was $2,000 and I had no income. I tried to negotiate with the landlord to break the lease early, but he insisted on keeping my $2,000 security deposit for leaving before the lease term ended. I moved into an extended stay motel near the highway. $40 per night. Thin walls. Stained carpet. A microwave and mini fridge that barely worked. My younger sister Brooklyn called 2 days after I moved. She said our mother had heard about the scandal through some connection in Austin's business community. Our family was from a small town 3 hours away where everyone knew everyone. Now people were gossiping about how I had tried to steal from my employer. Brooklyn asked me to just give TechVantage what they wanted so the whole thing would go away and stop embarrassing the family. She did not say it meanly. She was genuinely worried about our mother's reputation at church and in her social circles. I tried to explain that I had not stolen anything. I tried to explain that I had protected myself legally, and Derek was the one acting unethically. Brooklyn said she believed me, but could I please just make it stop? I stopped answering my family's calls after that. My LinkedIn profile started getting flagged with vague warnings from people in Derek's professional network. Comments appeared on my posts from months ago saying things like, "Interesting to see someone promote innovation while allegedly violating their employer's IP rights." I applied to 6 jobs at other Austin tech companies. None of them responded. A recruiter I had worked with before called me off the record. She said Derek had personally reached out to her firm. He told them I was litigious and unethical and advised against placing me anywhere. She said other recruiting firms in Austin had probably received similar warnings. I was being blacklisted. No one would hire me while an active legal dispute hung over my head. My body started breaking down under the stress. I could not sleep more than 3 hours per night. I lay in the motel bed staring at the ceiling, running through scenarios and possibilities, trying to find some way out. I lost 14 pounds in 3 weeks. My clothes hung loose. My face looked hollow in the mirror. I had my first panic attack in a grocery store while trying to decide if I could afford fresh vegetables or should stick to rice and beans. My chest tightened. My vision narrowed. I abandoned my cart and sat in my car for 40 minutes, waiting for my hands to stop shaking. I started seriously considering just signing everything over to TechVantage and disappearing. Maybe I could move to another city and start over. Maybe I could leave tech entirely and find some other kind of work. On day 6 of Derek's 7-day ultimatum, TechVantage filed the lawsuit anyway. The case was titled TechVantage Corporation v. Chastity Morgan. Seeing my full legal name on the court documents made everything feel more real and more terrifying. The claims were brutal: breach of contract, theft of trade secrets, tortious interference with business relationships. They were seeking $5 million in actual damages plus punitive damages to be determined at trial. A process server showed up at the motel at 7 in the morning to hand me the papers. He knocked loudly and called my name until I opened the door. Other guests were stepping out of their rooms to see what was happening. The front desk manager watched from across the parking lot. It was humiliating. I took the papers back inside and sat on the edge of the sagging bed reading through them. The legal language was dense and formal, but the message was clear. Derek intended to destroy me completely. I called Amanda Strauss and sent her the lawsuit documents. She reviewed them and called me back that afternoon. She said the lawsuit was aggressive but well-crafted. Even defending against it without going to trial would cost at least $30,000 in legal fees. She could not take the case without a substantial retainer that I simply did not have. Amanda recommended I consider filing for bankruptcy and surrendering everything to TechVantage. She said sometimes you have to lose the battle to survive the war. She said my health and future were worth more than one business venture. I had 72 hours to file a response to the lawsuit, or a default judgment would be entered against me. That night, I sat in the motel room ready to give up completely. I opened my laptop to draft a surrender letter to Derek's lawyers. I would offer to sign over everything and dismiss any counterclaims in exchange for them dropping the lawsuit. I would lose Night Owl, but at least I could try to rebuild my life. I opened my email to find Paul's contact information. As I scrolled through old messages, I saw a folder labeled TechVantage Onboarding 2018. I did not remember creating it, but apparently I had saved every document from my hiring process 6 years ago. I clicked through the folder aimlessly, not sure what I was looking for. Job description. Benefits information. I-9. Verification. W-4 tax form. Then I saw an email chain between Derek and Gloria from HR. The subject line was, Chastity Morgan offer letter final. I opened it. Derek had written to Gloria 2 days before I signed my original offer letter. His message said, just put the IP clause in like she requested. We can override it later when she gets promoted. She will be too excited about the title to scrutinize the contract. Gloria replied, Are you sure? That seems potentially fraudulent if we are planning to override protections we explicitly granted. Derek wrote back, It is business. Do it. The timestamp was clear. The intent was documented. Derek had deliberately planned to deceive me from the very beginning. I had the smoking gun. But then I realized something that made my hands start shaking again. This email chain was between Derek and Gloria. It was internal company correspondence. Using it as evidence could open me up to claims of unauthorized access to confidential communications. Derek could say I hacked company systems. He could file criminal charges on top of the civil lawsuit. I stared at that email for 2 hours, paralyzed by impossible choices. I had proof of Derek's fraud, but using it might destroy me even faster than surrendering would. I did not sleep at all that night. I sat on the motel bed with my laptop open, reading and rereading that email chain, trying to think through every possible consequence of using it as evidence. If I presented this email, Derek would absolutely claim I had accessed it illegally. He would say I hacked into company servers or stole confidential information during my employment. Corporate espionage, unauthorized computer access. Those were criminal charges that could result in jail time. But if I did not use the email, I had no defense. I would lose Night Owl. I would lose the lawsuit. I would probably end up owing TechVantage money I did not have. By morning, I had convinced myself of one thing. The email had come to my official company account during onboarding. I had been CC'd on it, probably by accident, when Gloria hit reply, all instead of reply. I had not hacked anything. I had just kept my own emails like any normal employee would. Proving that distinction in court was another matter entirely, but at least I had an argument. I found a new lawyer through an online legal forum. I posted my situation anonymously, describing the fraud without naming companies or people. A lawyer named Henry Caldwell responded, saying it sounded like textbook fraudulent inducement of contract. We spoke by phone that afternoon. Henry was a partner at a small firm that specialized in employment law and fraud cases. He had been practicing for 23 years and said he had seen variations of my situation dozens of times. He worked on contingency, meaning no fees unless we won. His firm would cover all costs up front and take a percentage of any settlement or judgment. I sent him all my documentation, including the email chain between Derek and Gloria. Henry called me back 2 hours later, sounding energized, in a way Amanda never had. He said this was exactly the kind of corporate bullying he had built his practice to fight. He said the email was devastating evidence of Derek's intent to defraud me. He explained that we had two strategic options. We could reveal the email immediately as part of our response to the lawsuit, or we could hold it back as a surprise for later. Henry recommended we file a response denying all of TechVantage's claims, but not reveal our best evidence yet. We would also file a counterclaim for fraudulent inducement, claiming Derek deliberately misled me to override my IP protections. This approach would catch Derek and Paul off guard. They expected me to fold. They definitely did not expect a counterattack. Henry filed all the necessary paperwork the next day, just hours before my deadline to respond. The documents were dense with legal language, but the core message was simple. I denied everything TechVantage claimed. I accused Derek of fraud. I demanded my original contract be enforced. Derek was furious. I heard about his reaction through Angela, who sent me a brief, encrypted message. Derek called an all-hands meeting at TechVantage the day after our filing. He told the entire company that I was now suing them. He painted me as vindictive, greedy, and dangerous. He said I was trying to destroy the company that had given me everything. He turned my former team completely against me. Tyler Nash, who I had hired and mentored for 4 years, posted on Twitter, "Imagine being so entitled, you sue your employer for success you created with their resources." The tweet went viral, 30,000 retweets. Comments piled up, calling me everything from delusional to criminal. My name was trending in tech circles, and none of it was good. I deleted my social media apps. I could not handle seeing what people were saying about me. 3 weeks after Henry filed our response, the court ordered both parties to attempt mediation before proceeding to trial. A neutral mediator would facilitate a discussion to see if we could settle without litigation. We met in a conference room at a mediation center downtown. Derek brought Paul and 2 other corporate attorneys. I had only Henry beside me. The mediator was a retired judge named Lawrence Kimball. He had white hair and a gentle manner. He explained the process and asked each side to present their position. Paul spoke for TechVantage. He claimed I had violated my employment contract, used company resources, and built a competing product in bad faith. He said they were willing to be reasonable, but I had left them no choice except to protect their intellectual property. Henry spoke for me. He said TechVantage had fraudulently induced me into signing away protections I had specifically negotiated. He said Derek had a pattern of exploiting engineers, and that this case would expose that pattern publicly if it went to trial. Derek's face turned red during Henry's presentation. After both sides spoke, Judge Kimball asked us to separate into different rooms. He would shuttle between us, trying to find common ground. In our room, Henry told me to prepare for a lowball offer. Derek wanted to end this quickly now that we were fighting back. Judge Kimball returned after 20 minutes and presented TechVantage's offer. I would surrender all rights to Night Owl. They would drop the lawsuit. I would sign a non-disclosure agreement preventing me from discussing any of this publicly. In exchange for giving up everything, nothing. No compensation, no acknowledgement of wrongdoing, nothing. Henry looked at me and raised his eyebrows. I shook my head. Henry told Judge Kimball we rejected the offer. It was completely one-sided and did not acknowledge the fraudulent conduct we had documented. Judge Kimball looked troubled. He said he agreed the offer seemed unbalanced, but that was TechVantage's position. He left to relay our rejection. 5 minutes later, Derek appeared in the doorway of our mediation room. Paul stood behind him, looking uncomfortable. Derek said we were wasting everyone's time. He said we would see each other in court, and he looked forward to destroying what was left of my reputation. Henry stood up and told Derek the conversation was inappropriate. Derek smirked and walked away. Judge Kimball came back looking apologetic. He said TechVantage had ended the mediation. We were going to trial. As everyone packed up to leave, Paul pulled Henry aside in the hallway. I watched through the glass wall as Paul handed Henry a document. Henry's eyes widened as he read it. His face went pale. He returned to me looking shaken. Paul had just revealed TechVantage's next move. They had filed an emergency motion for something called evidence preservation. The motion claimed that Night Owl servers contained code derived from TechVantage intellectual property. They were asking the judge to order immediate seizure of all servers and user data to prevent destruction of evidence. The judge had granted the motion that morning. In 48 hours, federal marshals would physically confiscate my servers from the hosting facility. Even if I eventually won the case, Night Owl would be destroyed in the meantime. 15,000 users would wake up to find the service gone. My reputation would be finished. Every venture capitalist and potential customer would see me as radioactive. Derek had planned this perfectly. Even if I won in court months from now, the victory would be meaningless. Night Owl would already be dead. Henry and I went directly from mediation to his office. We had 48 hours before the server seizure. Both of us knew that was not enough time to mount a successful legal challenge to the judge's order. Henry laid out our options, and none of them were good. We could file an emergency appeal of the seizure order, but appeals took time, and the standards for overturning a lower court's decision were extremely high. We would probably lose. We could transfer the servers offshore to a hosting provider in another country, but that would be illegal and would prove every accusation Derek had made about me acting in bad faith. We could shut down Night Owl voluntarily before the marshals arrived, but that accomplished the same result Derek wanted. I would be surrendering without fighting. I sat in Henry's office, feeling completely defeated. We had fought so hard to get to this point, and Derek still had moves we could not counter. Then Henry's phone buzzed. He glanced at it, and his expression changed. He turned his laptop screen toward me. Someone had posted on Hacker News, a popular tech community forum. The post was titled, TechVantage is trying to steal a founder's startup using fraudulent employment contracts. The post laid out my entire situation in detail. It did not name me specifically, but anyone in Austin tech circles would recognize the story. It included analysis of how the superseding clause trick worked and warned other engineers to watch out for similar tactics. The post had 2,000 upvotes in 3 hours. The comments section was exploding with people sharing similar experiences and expressing outrage. I had no idea who posted it. I certainly had not. Within 6 hours, tech journalists started picking up the story. TechCrunch published an article about employment contract traps. The Verge wrote about IP rights for side projects. Both articles referenced an ongoing case in Austin that fit the pattern, though they could not name parties due to legal restrictions. The narrative was shifting. What had been Derek's story, about a disloyal employee stealing from her company, was becoming a story about corporate bullying and fraudulent business practices. By evening, Night Owl users had figured out what was happening. Someone connected the dots and posted in the Night Owl user community forum, asking if I was the founder being targeted by TechVantage. I posted a transparent message explaining the situation without violating any court orders. I said a legal dispute threatened the service. I said I was fighting to protect what I had built. I did not name TechVantage directly, but I did not have to. Users started sharing my post across social media. Within 12 hours, the message had been shared 10,000 times. Tech workers rallied around the story. They saw themselves in my position. They saw their own side projects and weekend prototypes, potentially vulnerable to the same tactics. A GoFundMe page appeared. I did not create it. Some user had set it up to help with my legal fees. The description explained the situation and asked the tech community to support a fellow founder fighting corporate overreach. The GoFundMe raised $18,000 in 24 hours. I cried when I saw it. Strangers were helping me fight. People I had never met believed in what I was doing. TechVantage's PR team issued a statement calling the social media campaign harassment. They said I was manipulating public sentiment to distract from my contractual violations. They threatened legal action against anyone spreading false information about the company. The statement backfired badly. It made them look vindictive and out of touch. Inside TechVantage, cracks were forming. Angela sent me another encrypted message. She said Derek had been lying to the engineering team about what Night Owl actually did. He claimed it was a direct competitor to TechVantage's products. It was not. The teams were finally starting to question Derek's version of events. Angela sent me screenshots of internal Slack messages, engineers discussing how Night Owl served freelancers while TechVantage focused on enterprise clients. Someone pointing out that the technology stacks were completely different. Someone else noting that if Derek really believed his own story, why had he tried so hard to hide the details from employees? One engineer wrote, "I think we might be the bad guys in this situation." Angela said she would testify if needed, but she was scared of losing her job. I told her not to risk her career for me. She said it was not just about me anymore. It was about what kind of company TechVantage was. With the new evidence from Angela and the public pressure building, Henry proposed a bold strategy. We would file an emergency motion to stay the server seizure. We would attach every piece of evidence we had: the original fraud email from Derek to Gloria, the internal Slack messages showing Derek lied to employees, documentation of his pattern of exploiting other engineers. We would go nuclear. We would expose everything publicly through court filings. Court documents were public record. Journalists and users would see all of it. The risk was enormous. If we lost, I could face sanctions for improper disclosure of confidential information. Derek might file additional claims against me. I might end up in an even worse position than I was already in. But we were out of time and out of options. Henry filed the emergency motion at 4 p.m, 16 hours before the server seizure deadline. He attached the fraud email as Exhibit A. He included Angela's Slack screenshots as Exhibit B. He wrote a 20-page brief arguing that TechVantage had obtained the seizure order through misrepresentation and that preserving Night Owl's operation was essential to prevent irreparable harm. Court filings hit the public docket within 2 hours. Tech journalists downloaded the documents immediately. By evening, the fraud email was trending on social media. Derek's exact words: "Just put the IP clause in. We can override it later. It is business." The story exploded. This was no longer an ambiguous he said, she said situation. This was documented proof of intentional deception. At 9 p.m, I got a call from an unknown number. I almost did not answer. Unknown numbers had been mostly process servers and threatening calls from Derek's associates. But something made me pick up. It was Gloria Patterson, the HR representative from 6 years ago. She was crying. She said she had been watching everything unfold and could not stay silent anymore. She said she quit TechVantage 2 years ago, specifically because she was tired of being complicit in Derek's schemes. She had kept copies of everything, every email, every document, every instruction Derek had given her about manipulating employment contracts. Derek had done this to 4 other engineers before me. Gloria had documentation of all of it. She was willing to testify. I felt hope surge through me for the first time in weeks. Then Gloria said something that froze my blood. Derek was planning to file criminal charges against me tomorrow morning for unauthorized access to company communications. He had a detective friend in the Austin Police Department who would arrest me. Once I was arrested, the narrative would shift completely. The story would become about my criminal conduct, not Derek's fraud. I had maybe 12 hours before that happened. Henry and I worked through the entire night. Gloria sent her documentation through an encrypted email service. The files were extensive. Years of emails showing Derek's pattern of identifying talented engineers, making promises, then systematically trapping them through contract manipulation. Henry contacted a member of the Texas State Bar's Legal Ethics Board that he knew personally. He explained the situation and provided evidence that Paul, TechVantage's lawyer, had knowingly pursued fraudulent claims. The ethics board member said they would open an investigation immediately. Simultaneously, Henry contacted the FBI's white-collar crime division. He argued that Derek's scheme constituted mail fraud and wire fraud across multiple victims spanning several years. A federal investigation would take precedence over any local criminal charges Derek tried to file. By 7 a.m, we had filed supplemental briefing in the emergency server seizure case. Gloria's evidence was attached. The pattern of fraud was undeniable. At 9, we had an emergency hearing before Judge Patricia Whitmore. The courtroom was small and plain. Derek sat on one side with Paul and another attorney. I sat on the other side with Henry. Gloria sat in the gallery behind us, ready to testify if needed. Paul presented TechVantage's argument first. He said the server seizure was necessary to preserve evidence. He said I was trying to manipulate public opinion through social media. He said the court should not be swayed by online campaigns. He looked uncomfortable the entire time he spoke. Henry stood up and methodically dismantled every claim. He displayed the fraud email on the courtroom screen. He walked through Gloria's documentation, showing Derek's pattern. He presented Angela's internal Slack messages proving Derek had lied about Night Owl being competitive with TechVantage. He argued that TechVantage had obtained the seizure order through misrepresentation and that destroying a functioning business serving 15,000 users would cause irreparable harm that no monetary damages could fix later. Judge Whitmore listened without expression. She asked Paul several pointed questions about the fraud email. Paul tried to claim it was taken out of context. Henry produced Gloria's full documentation, showing there was no alternate context. The fraud was deliberate and systematic. Judge Whitmore took a 15-minute recess to review everything. When she returned, she denied the server seizure motion immediately. She said TechVantage's claims appeared substantially undermined by evidence of fraudulent conduct. She ordered both parties to return for a full evidentiary hearing in 2 weeks. She said she was inclined to believe my original employment contract remained valid and enforceable given the evidence of intentional misrepresentation in the subsequent contract. It was not a final ruling, but it was a massive signal. Derek's face turned purple. He started to say something, but Paul put a hand on his arm and shook his head. Within hours of the hearing, everything started cascading. TechVantage's board of directors received the court transcript and Gloria's documentation. 3 board members demanded an emergency meeting. By evening, Derek was suspended from his position, pending an internal investigation. TechVantage's stock price dropped 8% on the news. Major enterprise clients started calling to ask what was happening. Several requested meetings to discuss whether they should continue their contracts. Paul resigned from his position to avoid the ethics investigation. The firm he worked for issued a statement saying they were conducting their own internal review. 3 days later, TechVantage's new acting chief technology officer reached out through attorneys. They wanted to settle immediately. The scandal was destroying the company's reputation. They needed it to end. Their offer. TechVantage would acknowledge that I owned Night Owl completely and had developed it independently. They would pay $250,000 to compensate for any inadvertent company resources I might have used, though they did not believe I actually had. They would issue a public statement clarifying the situation and apologizing for the aggressive legal tactics. Derek would be terminated for cause. I countered through Henry. $400,000, public apology, restoration of my professional reputation, through positive references to any potential employers or investors, and an agreement that TechVantage would implement new employment contract protections for all engineers going forward. We settled on $375,000 in all other terms. I signed the settlement agreement in Henry's office on a Tuesday morning. The nightmare was over. The money hit my bank account 3 days later. I paid Henry his contingency fee, thanked him for believing in me, and asked him to be Night Owl's general counsel going forward. He agreed. I used the settlement money to properly fund Night Owl. I hired a small team. Angela joined me, along with 2 other engineers from TechVantage who were disgusted by what had happened. We moved into a real office space in East Austin with windows that actually opened and a kitchen that was not just a microwave on a card table. Night Owl's user base grew to 45,000 within 3 months. The publicity from the lawsuit had been brutal to live through, but it turned out to be incredible marketing. People wanted to support the product that a founder had fought so hard to protect. Venture capital firms that had disappeared when Derek sent his threatening letters came back. They saw the settlement as validation. They saw the user growth as proof of concept. I raised $2 million in Series A, funding from a firm that specialized in supporting founders from non-traditional backgrounds. I reconnected with my sister Brooklyn. I explained everything that had really happened. She apologized for not understanding before. Our mother called and said she was proud of me for fighting. It felt good to have my family back. Jordan reached out and apologized genuinely for his role in everything. We rebuilt our friendship slowly over coffee meetings and eventually became close again. He designed Night Owl's new website and refused to let me pay him. Gloria got a job at a nonprofit organization that helped workers fight employment fraud. She said our case had reminded her why she went into HR in the first place, to protect employees rather than enable executives. Derek tried to find work at other Austin tech companies, but the story followed him everywhere. His systematic fraud was public record now. No board of directors wanted someone with that history. He ended up as an independent consultant making less than a quarter of his former salary. I never spoke to him again. I did not need to. The truth had been enough. 6 months after the settlement, I was invited to speak at South by Southwest about intellectual property rights for startup founders. I stood on stage in front of 800 people and told my story. I talked about the importance of protecting yourself from day one. I talked about documentation and legal clauses and reading every word of every contract you sign. But mostly I talked about refusing to surrender when powerful people try to take what you built. After the talk, dozens of engineers came up to share their own stories. Some had lost side projects to employers. Some were too afraid to start anything because of their contracts. Some just wanted to say thank you for fighting publicly, so they could learn from what happened. I created a free legal resource guide for engineers with side projects. Henry helped me write it. We published it online, and it got downloaded 50,000 times in the first month. Companies started updating their employment contracts to be fairer. Some adopted clear IP ownership policies that protected both the company and the employee. The system was changing, slowly, because one person had refused to accept that the system was unchangeable. I learned that sometimes the powerful count on your fear, your isolation, and your lack of resources to make you surrender what is rightfully yours. They count on you being too tired or too broke or too scared to fight back. But documentation matters. Truth matters. Refusing to be silenced matters. I learned that I was stronger than I thought. That allies appear when you stand up for what is right, even if they take time to arrive. That winning is not just about keeping what is yours, it is about changing things so the next person does not have to suffer the same injustice. Most importantly, I learned that the fight is worth it. Not every battle is winnable, but some battles have to be fought regardless of the odds. Because surrendering means accepting that exploitation is just the cost of working in this industry. I stand in Night Owl's office now, watching my team work on features that will help another 10,000 freelancers understand their business finances. I feel grateful not just for the business success but for discovering my own resilience. I almost gave up so many times. I am glad I did not. The ending could have been different. I could have signed everything away that first day in the conference room. I could have accepted defeat when Marcus took Derek's money. I could have surrendered when the server seizure was ordered. But I kept fighting, and that made all the difference. Before I close this story, I want to ask you something. Have you ever been in a situation where someone in power tried to take credit for your work or claim ownership of something you created? How did you handle it? Did you fight back, or did you walk away? I would love to hear your experiences in the comments below. If this story resonated with you, please consider hitting the like button. It helps other people who might be facing similar situations find this story and know they are not alone. Subscribe to hear more stories about people who refused to accept injustice and fought for what was rightfully theirs. And please share this with anyone you know who might benefit from hearing about the importance of protecting yourself legally from day one in any employment relationship. Thank you for listening to my story. I hope it helps you in some way, whether that is understanding your own rights, finding courage to stand up for yourself, or simply knowing that even when powerful people try to crush you, the truth can still win. Take care of yourselves, protect your work, and never stop fighting for what you have earned.